Well, good afternoon and welcome to another 29 Bedford Row video presentation. My name is Nicholas Allen QC, and with me this afternoon is James Cooper. We are going to be speaking on the subject of spousal maintenance this afternoon. I'm going to be talking about nominal safety net orders and extension of term orders.
And I will be talking about the two key points in Waggett and how they've developed in the cases in the last couple of years. We thought about trying to cover all of spousal maintenance, but I think even the most enthusiastic listener wouldn't thank us for that. So we've picked out some narrower topics for us to focus on, and these are points that we found crop up in practice, and so we thought it'd be helpful to go over those with a narrower scope in more detail. And I'll pass over to Nick to get going.
There was a time when nominal spousal maintenance orders were made fairly frequently, certainly in courts in London and the South East. It was almost a given that if you had, say, a breadwinning husband and a homemaking wife and there were young children, then even if there was no need for a spousal maintenance order to be made, one would often be made, as I say, as a sort of safety net during the child or children's minority. There is no doubt that the tide in respect of those kind of orders has turned. The first of the cases where that began to happen is a case called Matthews and Matthews, reported at 2014 2FLR 1259. At first instance, Mr. Justice Mostyn had refused to make a nominal periodical payments order, and his decision to refuse to make such an order was upheld on appeal. In that case, there were very limited capital assets. Both parties earned in the low tens of thousands of pounds per annum. There were two children aged 6 and 3. The wife had been made redundant in the recent past, but had some employment in 6 of the last 12 months preceding the order. She argued that her fragile employment position required the protection of a nominal periodical payments order during the children's minority. What happened in the Court of Appeal was that Lord Justice Tomlinson, who gave the lead judgment, emphasised that the discretion to order nominal periodical payments must be exercised with regard to the statutory presumption in section 25A of the Matrimonial Causes Act in favour of making a clean break. And his rationale in the Court of Appeal is set out at paragraphs 13, 14 and 15 of the judgment. And effectively, he refers to an earlier decision of Mr. Justice Wilson, as he then was in S&B, which is a case in 2005, 1FLR 474, and effectively Lord Justice Tomlinson concludes that it is within the discretion of a trial judge to make or indeed not make a nominal periodical payments order. In other words, having made such an order, it's not vulnerable to being overturned on appeal. A number of people interpreted Matthews and Matthews as being authority for the proposition that you should never make nominal periodical payments orders. But as I've effectively already said, I don't think that is what that decision says. It effectively says that if a court does, or if a court doesn't, then it's not susceptible to being overturned on appeal. The second of the cases is a case called WD and HD, reported at 2017 1FLR 160, and that is a decision of Mr. Justice Moore. He was considering an appeal from a deputy district judge, and effectively the deputy district judge had not made a nominal periodical payments order, and he cites Matthews and he says, I have come to the conclusion, this is paragraph 63 of his judgment, I have come to the conclusion that it cannot be said that the decision of the deputy district judge was plainly wrong or outside the band of possible orders that she might have come to. Some judges would have retained the nominal order, she did not. So effectively WD and HD is almost an identical reflection of the same logic that was employed in Matthews and Matthews. Pausing briefly on a more recent decision of AW and AH, 2020 2FLR 519, Mrs. Justice Roberts made a nominal joint lives spousal PPs order in addition to adjourning the wife's capital claims for 7 years when she was satisfied that the bankrupt husband's financial position may recover in the near future. So the nominal order was made in that case, not so much as a safety net, but as to the fact that the wife's claims could not be fairly adjudicated on that occasion, but there may be a time in the foreseeable future where they could. So that's more akin to the jurisprudence on when it's appropriate to adjourn claims rather than dismiss them. This issue is very current because Mr. Justice Mostyn has very recently handed down a judgment in A and M. It's on Bailey, it's 2021 EWFC 89. And he has strongly said, and this is paragraphs 58 in particular of that judgment, where he says the practice of leaving a nominal order in place as an insurance policy is contrary to the statutory steer in section 25A of the Matrimonial Causes Act in favour of a clean break. He says under that section, the court is required to exercise its discretion so as to bring about a termination of financial dependence unless it is satisfied that to do so would lead to the claimant suffering undue hardship. He goes on to say to leave a nominal order in place because events may happen which might lead to the claimant suffering hardship, and he underlines the word may or might in his judgment, is not consistent with the terms of section 25A. The court has to assess the evidence, the court has to make findings, and if the court is satisfied that there is evidence upon which the claimant will adjust, or indeed has adjusted, to the termination of financial dependence, then he says that the statutory steer in section 25A means that the court needs to impose that clean break. And therefore the idea of a safety net looking at what might or may happen in the future is contrary to that. I'm not sure every judge will necessarily agree with that analysis, but we all know that the decisions of Mr. Justice Mostyn hold great sway. So it'll be very interesting to see where that jurisprudence develops. Finally, and in a case that Mr. Justice Mostyn refers to in A&M, there is an interesting decision of Deputy District Judge Hodson in the case of AJC and PJP, which is 2021 EWFC B25, where the Deputy District Judge suggests that one of the problems with nominal spousal maintenance orders is no one effectively knows the circumstances in which they are likely to be converted into substantive maintenance orders, and that therefore the criteria of making them is difficult because it leaves everybody dissatisfied as to whether or not they may be converted into substantive orders in the future. And certainly Deputy District Judge Hodson believes that an application under section 31 to convert a nominal order into a substantive order rather than an application under section 31 to convert the quantum of a substantive order to a lower or higher quantum, he suggests it's a different test. Again, a very interesting decision, well worth reading. But again, I'm not sure every judge will necessarily follow that analysis, but it was cited with approval by Mr. Justice Mostyn in A and M. James.
Thank you, Nick. So I'm going to talk about the two key principles raised in Waggett. Well, this is obviously a case from 2018, but there have been a few authorities in the last few years which have built on those principles, including A&M that Nick referred to. So I thought it would be helpful to revisit them. First point is earning capacity an asset that can be shared with a continuing entitlement to share in it? The short answer, no, but we'll talk about that in a bit more detail. And the second point is a bit more nuanced. To what extent should a party be expected to use their sharing award to meet their income needs? So starting with the issue of earning capacity as an asset, deal with this quite quickly because the unequivocal decision was no, you can't. It's not an asset you can share. The judgment of Waggett explores the reasons why that's the case. It conflicts with the court's ability to effect a clean break, because notionally that sharing would continue for a party's working life. And that feeds into the broader consideration that the marital partnership doesn't stay alive for the purposes of sharing after separation. And so says the judgment in Miller and McFarlane. And if you're going to pick a fight with the family authority, probably best to stay clear of that one. There are practical problems as well as these principled objections. Would it apply to every case with an income disparity? And how do you go about quantifying it? And how much would all of this cost? So lots of good reasons not to take that approach. And that's why, in the Court of Appeal's view, it's not the right way to approach the issue. Maybe not surprising that was their conclusion, because these considerations were all set out in Jones and Jones in 2011, where a similar conclusion was reached. It wasn't quite on all fours. That case was about capitalising a party's earning capacity at the date of marriage. But obviously, it's the same fundamental issues, and they formed the same view. So since Waggett, that conclusion has been reiterated, notably in O'Dwyer and O'Dwyer. There's very clear message in that judgment that the conclusion in Waggett on the point was clear and unequivocal. Also, and I said I'd come back to it, in A&M, Mr. Justice Mostyn's decision from earlier this year, there was a related point in that the argument was made for sharing in part of the husband's income for a period of years post-separation because of the wife's ongoing contributions to the family by way of childcare. Those arguments were rejected. Mr. Justice Mostyn described them as untenable because sharing is predicated on the economic partnership. And at paragraph 17, he wraps up that issue by saying, it would be a good thing if this argument were to finally bite the dust. So pretty clear view from, a characteristically clear view from Mr. Justice Mostyn on that. So on that note, moving on to, I think, what maybe the more interesting issue in Waggett, which is the application of a party's sharing award to meet their income needs. And should they be expected to do that, or are they entitled to maintenance on top of their sharing award to meet their needs? Now, when we say apply a sharing award, it's important to be specific about what that means, because you can do that in two ways. You can use capital to generate an income, or you can spend the money and deplete the capital itself by amortizing it. And that's an important distinction because there are very different considerations at play. For the first part of that, like generating an income with a surplus capital, yes, you're expected to do that. That's the conclusion in Waggett. With spare capital in any event, so obviously you're not expected to do that with capital that you need to use to apply your needs. It's only your sharing award above and beyond your needs that you should be attributing an income generation capacity to. What rate of return can you reasonably expect from that money? Well, the answer is not to look at the rate of return you can actually get from the money. The authorities say that's not a long-term view, and in particular, this is addressed in Waggett and O'Dwyer. There are advantages of taking the conventional Duxbury approach and using a 3.75% gross figure for that. This is explained in somewhat more detail in an authority from this year, ND and GD. That's a Mr. Justice Peel case. And he spends 3 or 4 paragraphs criticising the choice of the parties in the court to, the parties to instruct and the court to improve the instruction of a single joint expert to carry out these calculations. And his view, in most cases, a combination of using Duxbury and, if necessary, using capitalise is perfectly adequate for the task. So yes, you're expected to use spare capital to generate investment return, and in most cases, although the court retains discretion, the Duxbury calculations are appropriate to work out that rate of return. Now, what about amortizing the money and actually depleting the capital? That's a more nuanced issue. That's essentially what Waggett says. So it's a complicated issue. It's fact specific. You can't be categorical about it. There are a couple of competing factors that are raised. On one hand, Waggett refers to the factor of whether the financially stronger party will be meeting their needs from capital, or whether they can do that from income. And that weighs in the balance of fairness of what it's reasonable to expect a financially weaker party to do. Another factor is how much amortization is necessary, because we're not necessarily talking about depleting the whole capital fund, but it's a very different question of fairness if you're asked to eat into 5% of your spare money or 95% of it. So in Waggett, the outcome was that the financially weaker party was expected to amortise 21% of their spare capital, and that was considered proportionate in the context of that case. This is all informed by the statutory steer towards a clean break. And in short, it's context dependent, but the court is looking to achieve a clean break if it can. And if that requires some degree of amortization, a proportionate degree, then so be it, that's appropriate. Waggett was followed by O'Dwyer, and in Mr. Justice Francis's judgment, he broke down step by step how that analysis should be carried out in detail. The short version is that you establish what the spare capital is, you attribute income to it, you decide whether that should be amortized, if so, how much, and then you feed that into the standard maintenance analysis. But there's much more detailed step-by-step process set out in that judgment that's well worth reading. To conclude this point, again, going back to another case of Mr. Justice Mostyn, CB and KB in 2020, he addressed this issue at paragraph 53, and I'll read out his concluding remarks on this. I struggle to conceive of any case where, in the assessment of a claimant's need, it could be tenably argued that it was reasonable for her not to have to spend her own money in meeting them. After all, that's what money is for. Again, a characteristically pithy conclusion from Mr. Justice Mostyn. Not every judge will agree, and obviously that's in the context of the Court of Appeal saying you can't be definitive in Waggett, but it's certainly a clear view expressed by him and a helpful authority on the point when you're on one side of the case at least. That wraps up my short update on Waggett, and I'll pass back to Nick.
Thank you, James. And I'm going to deal finally with the thorny question of extension of term orders and what is the applicable legal threshold. Mr. Justice Mostyn, him again, in SS and NS at paragraph 46, where he lists the principles that he draws, the famous principles that he lists in the terms of spousal maintenance claims, expresses the view that on an application to extend a term order, there is no test or no criterion of exceptionality, but an examination should be made of whether the implicit premise of the original order of the ability of the payee to achieve independence has been impossible to achieve, and if so, why? Now, the history of this issue really dates back to a case called Fleming and Fleming in 2004, reported at 2004-1 FLR 667, where the original order was made by which the wife was to receive £1,000 per month for 4 years with no bar on an application to extend, no bar under section 28(1)(a) of the Matrimonial Causes Act. The wife applied to extend the term, and the first instance judge allowed the wife's application, reduced the quantum of the periodical payments from £1,000 a month to £500 a month, but converted the term order into a joint lives order. That went on appeal to the Court of Appeal, where the appeal was allowed. And the key dicta is in the judgment of Lord Justice Thorpe, where there is no doubt he set out a high threshold for extending a term order. He referred at paragraph 13 to there need to be some, quote, exceptional justification, unquote, for the court to exercise its power to extend obligations. And in the following paragraph, paragraph 14, he said that the payer had, quote, a legitimate expectation that his obligations would end, unquote, on the date provided in the order. Now, that high threshold, clear high threshold established by the Court of Appeal in Fleming, was referred to in Miller-McFarlane, the case that James referred to a minute or two ago in 2006, where the House of Lords allowed the wife's appeal against a 5-year term order and restored a joint lives order on the basis, amongst other reasons, that the Fleming test of exceptional justification, placed as the judgments of both Lord Nichols at paragraph 97 and Baroness Hale at paragraph 155, placed a high threshold on extending the term. In other words, they said it was unfair to put the burden on the wife to apply to extend the term because the burden as set out in Fleming was so high. But there is no doubt that when the case of Macfarlane came back for the second time on a variation application, reported at Macfarlane 2009 2FLR 1322, a very different view was taken by Mr. Justice Charles. He cites paragraph 97 of his judgment, what Fleming said, that I've already summarised, but then says this at paragraph 104. Notwithstanding the cross-reference to it by Baroness Hale of Richmond, see paragraph 155, the test or approach described and applied in Fleming does not survive the confirmation and the points referred to in paragraph 97. And he then comes up with a new test that says, in my view, the reasoning behind the earlier order that a party seeks to vary is a relevant circumstance of the case. And therefore, on an application to vary, it can be assessed whether the purpose of the earlier order has been fulfilled. And if it has, that this would be a relevant and perhaps a decisive factor in favour of refusing an extension or variation. In other words, the logic that seems to be applied by Mr. Justice Charles is that in some way, Fleming did not survive Miller Macfarlane. And with the greatest of respect to Mr. Justice Charles, I've always slightly struggled with that logic, because if Fleming was applied in Miller Macfarlane, I can't understand how it didn't survive Miller Macfarlane. But that is the view expressed by Mr. Justice Charles in Macfarlane number 2, when he set out a different test, which is the one that I've just read out. Then in a case called G&G, which is reported at 2012 2FLR 48, Mr. Justice Charles agreed with himself at paragraph 145, where he said he remained of the view he had expressed about Fleming in Macfarlane number 2. Fleming, Miller Macfarlane, Macfarlane number 2 were then all referred to by Mrs. Justice Eleanor King, as she then was in a case called L&L, where she said at paragraph 76, it is not necessary for me to consider the current state of the law on extendable terms. Fleming was then approved by the Court of Appeal, albeit it was by the same Court of Appeal judge, Lord Justice Thorpe, who'd given the Fleming judgment in Yates and Yates. That's at 2013 2FLR 1070, paragraph 9 of the judgment of the Court of Appeal. But then, as I've already foreshadowed, Fleming was queried by Mr. Justice Mostyn in the SS and NS decision. He says at paragraph 44, both parties here agree that the spousal maintenance order should be for a term, but they dispute whether it should be extendable. How easy is it to enlarge an extendable term? He cites what the Court of Appeal said in Fleming. He then cites the different test that Mr. Justice Charles had set out in Macfarlane number 2, and then says that he agrees with Mr. Justice Charles. And he effectively then says the test should be the one that is set out at paragraph 104 of Fleming. Forgive me, paragraph 104 of Macfarlane. So we have these differing tests, one set by the Court of Appeal and one set by the High Court. So it's fair to say that it is difficult now to advise our clients on the applicable law, particularly where the Court of Appeal and the High Court take different views on the law that should apply on an application to extend a term order. So that's it on our 3 discrete issues. Thank you very much indeed for watching this video. We hope you will watch other Bedford Row videos, and thank you and goodbye.
Thank you.